Hello. Latent defects. Again. Uh, what should you know before you claim or pretend that the property you bought has a latent defect? And what you should know before, as a seller, accepting that there was a situation of a latent defect. Uh, not every problem with a property sold or bought is a latent defect, or vis caché, as it's usually called in Quebec. Vis caché is latent defect, basically. First of all, if the seller knew about the problem, for example, the seller knew about the cracks in the foundation, or about the problems with the roof, or some plumbing issue, or rats, or insects, or whatever, then it doesn't fall within the scope of the latent defect problem. It's another problem. And whether the defect was latent or not, still, if the seller knew but failed to disclose it to the other side, the seller might be responsible. Of course, in reality, there is a difficulty to prove if the seller actually knew. Though sometimes it might be found in some inspection reports that the seller previously ordered, or in some sort of a contract to rectify it before some municipal permits that were issued and so forth. So not always it's impossible, but at least it takes some time and certain research, sometimes even a private investigator, right, to find that. There is also another difficulty, the question if the seller when the seller actually didn't know, because the seller, for example, was not living there, it was just always rented out, or the seller was not there for quite some time. But if the seller should have known, for example, if the seller would have complied with certain regulations, the seller would necessarily encounter that there is a certain problem when it comes to like pipes diameter, for example, or about some sort of floods in the basement, or about certain level of smell, odor on the property, like indicating mold, or some cracks on the walls, indicating that the whole construction is skewed and so forth. So even if the seller was willfully blind, let's put it this way, to something that if the seller was diligent, that's the word the courts usually use, if you were a diligent owner, you would know that. And very often it is used as a proof that the seller knew or just deemed to have this knowledge. This kind of defect usually is not even protected by the fact that you sold without legal warranty. So if, as a seller, you don't want such a problem, it's better to disclose wherever the problem can be found on the property. And before even disclosing, it's better to just find out and be reasonably diligent in finding out. Because sometimes, for example, there is some title issue on the property. Some time ago, it was like one house or one owner. Then because it was big, it was sold separated, and for a long time, for example, both owners were using the same basement without any problem, but in reality, like 2/3 of it was occupied by one and only 1/3 by another, and that happened for like 15 years, 20 years, 30 years. Then somebody died, then the heir sold the property, and the new buyer found out that in reality he can use a lesser space than it should have been, because the title was not properly verified, was not properly protected. It also might be a kind of a problem that the seller might not even think of. But he or she or they should have known. Legal warranty usually protects from the responsibility for those latent defects. Latent defects are those that might have developed invisibly, even with a diligent seller, somewhere like in the walls, for example, in the pipes, some like a rust, some clogging, maybe some also not so much noticeable like foundation sinking, or maybe just the fact that the roof was like really old, or some wooden beam was old, or several of those, and so forth. So very often when you're an heir, for example, and you are selling some property that you did not use, it was used by your great-grandfather, for example, and now you don't want that property and you know that the property is not in a good condition, then you sell it without legal warranty, which usually covers for latent defects, but not for all of them, as we just discussed. Not for the question of all defects, because not all of them are latent, actually. Now, what, as a diligent seller, you might do to, again, prevent such a problem? In the very phrase, in the very term latent defect, you can see that there is a word latent, which means that if there is any claim later, but you can prove that the defect was not latent, that the buyer actually knew or should have known about it because of visual inspection, because the inspector's report, because of the seller's declaration, because of any kind of disclosure that you could prove. For example, you sent some previous inspection reports where the problem was clearly presented, or some documents from your syndicate, if it's a condo, for example, and there are some bylaws or some decisions of the administrative board or the General Assembly that clearly indicates some kind of a problem or some kind of a contingency fund requirements or so forth. So if to protect yourself, you made it sure that the buyer at least received those documents. You cannot make it sure that the buyer actually read them, but you made them available to the buyer. Then the buyer, a diligent one, would be presumed to have known, or probably if you even discussed some of it and decreased the value for the property because of something of those, then you're clearly protected from a claim for latent defect because it was no longer latent. If something was clearly visible, it might be a good idea to make some pictures, not only for herself, but again to send them to the buyer to show that there was like some stain on the wall, for example, or the ceiling. Some of it might even go in your listing. It would be much worse if something not only hidden from the buyer, but you made some misrepresentation in your listing or about for the communication. And sometimes it's not because it's your fault as a seller. It's not uncommon then the real estate agents prefer not to disclose some information in order to just ensure the deal and to get the commission faster. It happens, and unfortunately, very often it might be then the seller's problem. So it's better to make it sure that whatever information, even if you do not think that there might be something, for example, in those documents from the syndicate, but just in case, provide. And of course, keep proof that you have provided, like a copy of that email where you sent it, a copy of that letter. If you send it like with a hard copy, then download from the Canada Post site the proof of delivery and so forth. If the buyer, as nowadays most of them do, invited an inspector before buying the property, before proceeding with a notarial deed of sale, uh, it's not a guarantee, because the inspector is there only to observe, again, what's visible. Normally, the inspectors, at least in Quebec, will not like drill your walls, will not open walls, will not open floors, will not go to the attic. If it's winter and the roof is covered with snow, they will not go there to remove and so forth. So the inspectors only put in their reports what was visible. They are hired eyes mostly. They're not experts. Of course, the inspectors also have their own responsibility. So to protect that, it's again not unusual that in their report there might be something in like small font or some not very clear indication that something might present a problem, and you should verify further. And if you do not, as a buyer, if you do not read it closely, diligently, then later if you complain, the seller might put it in your face saying that, you see, it was said here that there was some kind of like moist somewhere, some smell somewhere, some stain or crack somewhere. And even though the inspector didn't specifically say that it was due to some like flooding, but the inspector said that it should be further investigated, further looked through. And you didn't. Therefore, you didn't do your due diligence. And in that situation, in many cases, the defect is not seen as latent because, again, you are presumed to be a diligent buyer, so you should have made further inquiries about that. It's understandable why the inspectors do that, because they want to protect their responsibility. Because if the seller can prove that something was clearly visible and might indicate a problem, but the inspector failed to mention that in the report, then the buyer could go against the inspector for this failure. So it's advisable to read the inspection report like meticulously to see those indications and to decide and to verify. Then, if as a buyer you found out that something was wrong next day or next week or next month or at least next half a year from the sale, the seasons changed, you found out something, then as long as you reasonably immediately informed the other side and you just negotiated a solution, at least there might be a claim. But if after 5 years of being an owner, you found out that something was wrong, first of all, it's hard to prove now that it was wrong at the time of a sale, because, well, problems might develop later. And second, again, the courts usually, not always, but usually use this notion of a diligent buyer, saying that, well, it was your property now, it was your due diligence to verify everything. And if you failed to do that, then now maybe 100%, maybe 50%, maybe 75%, well, whatever the percent, but it might be in full or in part your fault. And therefore, because again, there is an obligation in the Civil Code of Quebec to diminish your damage. So once you had the means and opportunity to verify and to rectify or bring up the claim, and you failed to do that for quite some time, usually it's like after a year and further on, 3 years, 5 years, the longer you wait, the harder it is to get some judgment in your favor. Even worse if you learn about something like quite soon, and then for years you fail to do anything about that, thinking that, yeah, maybe later, maybe later. Again, there will be a question of proof. But if you're an honest person and before the judge under oath, you're asked, when did you discover that? And you will have to say that you did 2-3 years ago, then the question would be, where were you for all this time? So if you bought a property, it would be task of due diligence to verify it all, and if you found something, to notify the other party as soon as possible. Also, some people, unreasonably, when they find a small, even it's a proper latent defect but small one, they think that they might claim more, so they do not inform it first, and then they do some like significant renovation, and then try to claim all that from the seller. But again, the code says when you found something, if it's not urgent, so it's not like it does not threaten your minor child, for example, right away, you should not rectify it on your own. You should first contact the seller and ask the seller to rectify. And only if the seller categorically denies and does not want to cooperate, then, and again, if it's still relatively urgent, you might proceed with the rectification and then ask the court only to compensate you. But usually judges prefer if you first went to court, asked for the solution, and only if the judge ordered either the seller to rectify or the seller to pay to you, only then you proceed with the rectification. Again, it depends on how urgent it is. So, as you can see, the clear and reasonable advice for both the seller and the buyer would be to demonstrate due diligence, for the seller to verify and then to disclose as much as possible, for the buyer to verify the report, to verify the property right after that, and again disclose whatever is found as soon as possible. Based on that, most of cases of latent defects are resolved by an agreement between the parties, and they don't even go to court, because there are also the questions of costs. And whenever a potential solution is beyond 15,000, it will not go to the small claims court already. It will go further to the Court of Quebec, sometimes even to the Superior Court of Quebec. Then there is a question of lawyers' fees, and this question might outweigh all the benefits of a positive judgment eventually. So, again, if you are diligent enough, if you're reasonable enough, most probably it will be settled. But at least, based on what we have discussed, you would better know if you have a claim, or if you're the seller, if the buyer really has a claim in your situation. Thank you, and have a nice day.